you 50 minutes in which to present the cases. I said, help me have 5 minutes to retain for rebuttal. If you wish to retain that time, let me know and come up to the podium. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. And again, we have regular briefs in the way. See you anyway.
Thank you, Your Honor. Just so I understood you right, you said I could have as much as 5 minutes for rebuttal?
Yes.
I'd like to take that.
Okay, thank you.
Thank you. I do know that you've read our briefs carefully. One of the things I wanted to say at the beginning, though, was that one of the issues that's in this case, whether it's really looked at by this court, and it may not be, but it could be looked at by another court, is the fact that, as I know the members of the panel know, this action would be governed by the statute in the Ohio Revised Code that provides for residential property disclosure forms. The statute says one thing, and the residential property disclosure forms say another thing. But the truth of the matter is, and there's not any question about the fact that I've handled a number of these cases over the years, what's happening in the case law is that says something else. And I would take the position just in general, and while it may not matter here, it may matter somewhere up the line, that I just think that this Ohio Revised Code statute, by decisions at the trial court level and or the appellate court level, that don't let these cases even go to trial, is something that maybe the Ohio State Supreme Court needs to pass on. I don't think there have been many cases in many years that the Ohio Supreme Court's passed on here, because these are small cases by and large. Nobody can really argue much about the law, because the law is what it is. But if you're having a situation where, as somebody who's represented a lot of plaintiffs, that it seems like practically anything that you put out is going to go down on summary judgment, I think that needs to be reviewed further up. One other thing about that, which doesn't really play a role in these cases, is there is the occasional case like this that comes out where a defense will be, and this wasn't a big defense in this case, or a big issue that the trial court picked up on, but I've seen decisions before where a trial court and even an appellate court will sometimes say, if there's an as-is clause in the purchase agreement, and there isn't every one, because these are virtually all drafted by real estate companies. You know, once in a blue moon you might see one that doesn't have it. But that's been held before too as a defense that you can't get passed on summary judgment. That means that the statute's been voided, basically. So, after that, to get more back to this case, one of the cases that I cited in my appellate brief that I'd like to call to your attention, and again, I know that you've read these, is the Ferguson decision, because the Ferguson decision is a case that's not old. These are not really old cases, not to be trivial about it, but the case that probably gets the most attention now in the United States would be Roe v. Wade, not this case, but a 45-year-old case. Based on that, this is much different than that, but this, I think, is a 10-year-old case. And what Ferguson says is you don't get past a summary judgment, let alone moving to sanctions, if there's a genuine issue of material fact, even if there are some disclosures made on a residential property disclosure form, and even if there are some things in a home inspection that say you may have an issue here. That was what the law, I'm not aware of, that was what the law's been for many years, and I would take the position that it still is now, which I think is one of the reasons why perhaps, whether it's an appellate court or the ultimate court, these are decisions that a court needs to say, look, this is the law still, and you can't get out on these cases on summary judgment all the time, just because there's a little bit on a disclosure form, or a little bit on a home inspection, or they will say, yes, you can. And if that's the case, I think people should know that, because I think it's important here. I cited some cases of mine, and I cited, in addition to Ferguson, one other case at about that section of the appellant's brief, give or take around page 13, that was tried by somebody else. And in that case as well, the decision was, you know, you don't get past these things on summary judgment that easily. Now, the next point I'd like to make is that some issues have come up that I'm not sure were completely clarified in briefs. I think they were touched on. During the hearing in front of the magistrate, Attorney Weiner gave testimony vis-a-vis my cross-examination. And as I think you will recall, there were two significant portions of the damages that were presented to the magistrate at that time that had been redacted. I don't know whether or not you have copies of what was redacted or not, but I at least referenced them enough in the transcript there. I'd clue you to maybe somewhere in the neighborhood of that transcript in front of the magistrate, pages 39 or 40 or 42. It's in that area. Now, what it said there was that on April 13th, 2016, she was already working on a motion for sanctions, researching that. Her testimony in there, I think, and certainly the record would show this was before she even filed an answer, before she even conducted discovery, before she defended any discovery, before anything happened. That was the first thing, and she felt that that was something significant enough to hide from me or attempt to by redacting it. There aren't that many redactions in the sets of the alleged time records from this attorney. There might be 5 or 6, but this is one redaction, and I think that's important, because somebody had made up their mind already here. And if that's the case, I disagree with it, obviously, that's why we're here today. But why go through all of this without communicating to me that you think it's this far off base, or this is the way you intend to proceed? Because that gives me a chance to discuss it with my client and say, look, whether we agree with it or not, a case is going to kind of be multiplied into 2 cases. Do you want to proceed on this or not? And the other redaction in there, which I think, according to my notes, is exactly on transcript page 42, she redacted the fact that as early as May 12, 2016, there were discussions between the clients and these attorneys about offers to settle. Well, nothing ever happened. I don't believe, and this again was something she wanted to cover up for me, so it was redacted. Initially, I didn't see the unredacted portions of this until we were actually in the middle of that hearing, when they came in as evidence. I put it to you as a related matter, members of the panel, that there is something seriously strange about whether you're talking about clients, the McAdams in this case, or their counsel, when they know perfectly well that the, for lack of a better way to say it, the guts of the case is what the repair costs are on the basement, which was about $14,500. And you're going to, as a reasonable person, run up something that triples that? I mean, it made me wonder, and I was going to argue that concerning my motion, but I got the ruling on the motion, so I won't get into that. But I just really have to wonder why reasonable people who didn't think they really knew what was going to happen at the trial court level would run numbers into the ground like that when the case was basically only about worth $14,500, probably could have been settled for a third. So we're looking here now at $40,000, which I find to be preposterous. Now, another issue I want to discuss, this came out a little bit in my motion and in the response, but it was also part of what's been argued in the appellant's brief and the appellee's brief. In the hearing in front of the magistrate, a very odd thing happened. Now, I'm not going to say too much that's not on the record, but when we were getting ready to proceed, there was a magistrate there ready to go, and there was a court reporter ready to go, and there were some other people there. Me, opposing counsel, I think the clients. 3 young women literally ran into the court, and they ran in and they sat down behind me where I couldn't see them unless I turned around and looked at them. Now, as you might remember from the motion that I filed and the reply brief to it, the way it's worded is that I demanded to know what their names were. I do that in any case if I want a separation of witnesses, because I don't know who they are and I don't know why they're there. And I also said specifically, and I think that is on page 5 of the transcript for the magistrate's hearing, just wanted to make a motion more or less, and it's in there, to separate witnesses. And I was then informed they were court employees. Now, why, when there's a magistrate there to have a hearing and a court reporter to take everything down, are all of a sudden 3 people running in from the court with notepads? I don't know, and that's not in front of you to decide, but I am telling you that that's why I asked, because that was very odd conduct, and again, how am I to know people I've never met aren't there possibly to be witnesses? And I said, I'm looking for a separation if possible. And if they were court employees, they were court employees.
And with that, Sue, we have 5 minutes left.
That's really all I have right now, except rebuttal. Thank you.
Thank you.
Thank you, Your Honor. May it please the court, my name is Colin Skinner. I represent the appellees, Pat and Rebecca McAdams. And if the briefing and some of the arguments have been all over the board on this, so with the court's indulgence, I'm going to follow 4 broad themes in my remarks. The first will be related to the Ohio State waterproofing, this what I call a cottage industry that's created between them and counsel in order to bring cases like this. I'm going to address the weakness of this particular case, and I'm going to touch upon the disparaging of the trial court, and then finally, if I have time, I'm going to try to get to the amount of the sanction in this case. Now, if you look through the hearing transcript for the motion for sanctions, you will see that multiple times what happens is an Ohio State waterproofing estimator will arrive at somebody's house. He will take photographs. Those photographs become trial exhibits. When the foreman completes the work, he immediately generates a letter, within a day or so, generates a letter that becomes an expert opinion. And then all of these disparate plaintiffs from multiple counties across Northeast Ohio end up with Attorney White. We don't know how many times. We know there's a lot. He mentioned himself that he couldn't cite all the cases. We know there's at least 30 unsuccessful cases from the appellate record. We don't know how many times a year, because when he was questioned at page 44 of the transcript, he basically was evasive and refused to answer how many cases he gets a year from him. He wouldn't even admit that Mr. Oehler was referred to him. He would not explain why Ohio State Waterproofing repeatedly pays its own employees to provide him with expert reports, expert testimony for deposition, and presumably expert testimony for trial. He gave no reason for that, but we know that this is a very high volume business, and I think part of the sanction in this case was his evasiveness, explaining what exactly this relationship was and how he managed to get it. We're talking about a man that has no website. He does not advertise. He does not even have a sign in front of his office, yet he manages to collect dozens of clients from all over Northeast Ohio, all of them referred by Ohio State Waterproofing. If someone refers all your cases, one has to wonder who makes the decision about whether to file a case or not. He testified that he charges $50 an hour for his services. He did not explain why he put so little into the case. He did not act like someone that was getting paid by the hour. He took no depositions. He did no discovery. He did the absolute bare minimum that he could get by. And I think a big part of the court's reason for sanction was, and it even said, it cited in the opinion, he did not dispel this coordination, I believe was the term the court used, in explaining himself. And there was evidence of misconduct, I think ample evidence, in order to survive an abuse of discretion standard. I mean, this process victimizes people. These kind of cases aren't covered by insurance. You've got someone who presumably has moved recently, just sold a home, just bought a new home. This kind of case, and he even said in his oral argument here today that they don't survive summary judgment, which brings me to the weakness of this case. Essentially, when he filed this case, and the court questioned him about this extensively as well, he knew that the basement had been painted, and he knew that he had his canned expert report that has been produced in potentially dozens of cases. The one-page expert report that says this did not develop overnight. He claims in his brief that painting alone is sufficient to overcome summary judgment, but it's not. There are plenty of cases, they're his cases, that reject that argument. Another thing that he ignores, essentially, many of Mr. White's arguments in this have been circular. For instance, he says that the pipe that was discovered by the waterproof people was put there to remedy a wet basement condition. That's not the testimony of the people that put it in there. There was grading issues, there's external drainage issues, there's the fact that new downspouts were put in and a new pipe tied together. Plenty of reasons why one might put in a pipe that had nothing to do with water in the basement. The other circular logic that he goes through is on the disclosure form. The disclosure form asks if you have knowledge of a problem. And if you answer yes, you have knowledge of a problem, then you write down an explanation of what you did to remedy that problem. Attorney White assumes that all the repairs my clients made when they got and they rehabbed this house, they bought it out of foreclosure and they rehabbed it and they sold it. They did all kinds of cosmetic repairs to this house. There was probably not a surface in it that wasn't painted, including the basement. You can't draw an inference because they didn't, that made repairs, that they made repairs to conceal something. There's some real issues with that. For instance, there were real weaknesses with this case. The fact that the seller had only owned the house for a very short time while he flipped it. The fact that the seller was not an occupant and therefore might not have a great deal of knowledge about what happens in the basement. The fact that there was a clean inspection that noted no problems with water. The fact that there was a clean appraisal that noted no problem with water. And Mr. White should know this because case after case of his own, which is cited throughout the transcript, are cases that found that painting alone is not evidence of concealment, and also found that that the other issues, the painting alone is but one of them. The non-occupant, the short-time owner, all of those things are considered significant weaknesses in a fraud case where you have to prove prior knowledge. This case was very weak when he filed it. He only learned of the repairs that he complains of now as part of the summary judgment process because they were voluntarily put in affidavits by my clients to explain what they did to this house. He did not know them when he filed the complaint. He filed the complaint, he knew painting, and he knew that. The other issue is the fact of the flooding. Mr. Oehler testified he lived in a house, it was 3 or 4 months. In June of 2015, there was a very substantial flash flood. The basement flooded during this rain event. It took him 6 months to get this basement repaired, and he didn't experience any other flooding. This was an isolated event, which suggests A, no prior knowledge on the part of my client, and B, no recurring problem to be repaired. The other exception I take with this case is the Attorney White's constant accusing the court of misconduct. He claims that it's misconduct not to rely upon his cited authority. Most of it is old. The trial court relied upon recent appellate decisions from this jurisdiction. There's no requirement for the trial court to cite every single case and distinguish every single case put to it. It had good precedent to follow. Most of his citations are to common police court cases that A, aren't binding precedent, B, aren't properly in the record, and were of no use to the court whatsoever. I'd like to defend the court's honor on this. These allegations of misconduct, he's alleging in his motion to stay and in his brief that because I said hello to someone because I recognized her name in a hearing that somehow Judge McCarty, a jurist that's been a judge, I think, for probably close to 20 years, is going to throw a civil case in order for what? To do a favor to a law student that happens to work at the courthouse? It's scurrilous and it's baseless. And I will say that I'd like to say on the record that the content of that conversation that he alleges is a complete fabrication. I recognized this woman's name. I said, I worked with her father. I said, hello, I worked with your father. It's pleasant to meet you. I shook her hand, and that was essentially the sum total of that conversation. It took place in open court within several feet of this man and in front of other court employees. There's absolutely nothing wrong with it. This is a small town. Lots of us know each other. I knew everybody in the room, had met virtually everybody in the room before, and I probably passed a dozen people in the hallways that I knew as well. And finally, I'd like to get to the damages or to the sanction amount. He makes much of the fact that this was a $15,000 case. It wasn't. It was $15,000 plus attorney's fees plus punitive damages. And my client, who buys and sells homes for a living, considered that an unacceptable mark on his reputation to settle a fraud claim. So he decided to fight it. We charged $200 an hour. It's not a shocking amount for this town, as our expert testified. We did one round of written discovery. I took 2 depositions. We hired an expert because he had one of his own, and we prepped that expert, and we moved for summary judgment. I don't know how to do less. Sometimes, if you're going to actually fully defend a case, it's going to cost what it costs. It's sometimes difficult when the amount of controversy is not that high, but there's nothing wrong with it, and everything we did was appropriate. He made much of the fact that our expert did not know Ann Weiner. Ann is a very competent counsel. I enjoy collaborating with her. I consider this essentially to be her client, her case. She did most of the work. She's very experienced. It doesn't matter that the expert knew her or didn't know her. It's not a popularity contest. The idea is that he's supposed to look at her work, look at what was billed for it, and opine whether it was reasonable. It's actually beneficial if he doesn't know who she is. He's judging her work on paper. That's the way it's supposed to happen. And finally, in his 3rd reply brief, Attorney White raised the issue of this Newman versus Al Castrucci Ford, the issue being, can you include as part of your sanctions the fees that you expended in moving for sanction? First off, at the hearing, you can tell at 38 and 39 of the transcript, he had those bills prior to the hearing. So he could have objected to that at the time. He did not. He waived the argument. It's also not in his merit brief, so he waived the argument by not raising it there, and it wasn't really included until his 3rd reply brief. I believe he's waived the argument, and even if he hasn't, while I couldn't find that this court has opined on the issue, lots of courts have gone the other way. The most predominant case is Sweeney versus Hunter, 76 Ohio App 3rd 159, explicitly rejected Newman and said that you can indeed include those fees in your sanction. Followed by Pracker versus Dolan, a 1995, unfortunately, Geauga case. It's unreported, 95 LW 2972. And Schneider versus the City of London, 1996. It's Madison App 96 LW 4422. I apologize for having to give you citations at oral argument, but it was in the reply brief for the first time. And finally, he mentioned the redactions. I don't know that I saw that anywhere in the briefs. I think any practitioner that has to produce fees thinks about an inadvertent waiver of attorney-client privilege and wants to redact some of those things from the bills in order not to disclose anything or any attorney-client communication. We did that initially, and then after some thoughts, we thought, well, the expert needs to go through that, and if the expert's going to see unredacted bills, then Attorney White gets unredacted bills, which he acknowledged he received prior to the hearing. So there was nothing unusual and nothing nefarious about any kind of redaction that was put in there. Finally, he's made much about the fact that the court hadn't served him with the magistrate's decision. If you look at the docket, he withdrew his counsel for shortly after the motion for sanctions. So somebody inadvertently, not realizing he still had an interest in this case, dropped him from service because he was no longer counsel of record. I'm speculating somewhat on that. but that seems to be the most logical explanation of why he was not necessarily served with those later orders in his court. And my final say on that would be that there's an actual mechanism within the rule itself. If you don't get notice, you ask the court for notice. He had sufficient time to file this appeal. He could have asked this court to remand the matter while he did objections. I mean, that's essentially the remedy that the rule provides. He didn't avail himself of it, so he's waived that argument as well. Thank you, Your Honor. If you have any questions, I'll entertain them. If not, I'll sit down.
Thank you. You're right, you have 5 minutes 4 minutes and 52 seconds, I'm sorry for the rebuttal.
Okay, I'll talk fast, I think I can get through this. This case, and it's interesting that he would start his oral arguments, is more of a referendum somebody had on Ohio State waterproofing and/or me and history than anything else. It had not much to do with the facts. Somebody's decided they don't like waterproofing companies doing this. They all do that I've run into. Ohio State happens to be the largest. I've gotten referrals from a dozen waterproofing companies over the years. They're just that some I might get a referral every 2 years. They don't do the volume of work. I don't know how that differs than if I ran an ad on TV and got referrals based on an ad on TV. If I did mesothelioma work or personal injury work, I don't see anything wrong with that. Now, the reckless assertion that this is all I do, if anybody would care to, anybody could check a municipal docket in any court within a 100-mile radius of here or more. I had a period when, just as one for instance, you don't want to hear my history, but I had a period of one time, back when you saw these TV commercials, if you have too much credit card debt, call 1-800. I happened to get a referral from a client who referred somebody to me who did some of that work. All during the last 6, 7, 8 years, I had hundreds of those cases, if not 1,000. None of them went to trial, it was just a matter of what they were. But search my name in any court you want to, any municipal court, some as far away as Cincinnati, some as far away as Toledo, some next door in Akron Muni. Hundreds of those cases. And I've had other cases as well. So for somebody like this to say, well, you know, these are the only cases, he wouldn't have the first clue. And if he does have the first clue, and he may, it's the kind of arguments that we've seen on behalf of these people throughout. Now, on another page, or on another thing, this case, as far as it being weak, this is one of the strongest cases I've ever had. We had professional flippers who completely did everything in the house, including what is obviously waterproofing work. I heard today the same thing I've heard before. Well, the fact that they did waterproofing and rerouted water away from the house, that doesn't mean that they did waterproofing. That's the only thing this could have been. You don't do the waterproofing work they did here to fix the roof or to paint the garage. That's a nonsensical argument. These things were clearly done. Now, a tired argument that I get, and I got the same tired argument today, is, well, these people were just flippers. I'm not trying to be flip when I tell you, if you're in business as a flipper, you probably really know more when you've rehabilitated a house from stud to stud and from basement to roof. You probably know more than I do about the house I've lived in 21 years. I'm not smart about things like that. These people had more knowledge about that house than anybody's had about that house in 20 years because they completely rehabilitated it and they completely flipped it. And the fact that they didn't reside there is a nonsensical argument for people. You might as well say somebody who built a house and sold it to me didn't know anything about the house because I lived there, but he just built it. That's nonsensical. Now, another thing that's not nonsensical, but it's dishonest. I knew what had happened in that case because my client told me what the defendants had done, and I'd also seen the expert's report before I filed the complaint. Now, what happened here is Attorney Weiner, at $200 an hour, filed some papers with the court that said everything that her clients did. So if you looked into this case, if you were curious about the people who were sued and whether you want to buy a house, you don't even have to read anything I wrote. You can find out exactly what they did from Attorney Weiner's submissions, not from mine. And as far as his clients running up this kind of fee bill with their help, while apparently, well, I'll leave it at that, with their help, they knew there was an issue here when Attorney Scanlon sent somebody who represented them at the time, I don't think these people, a letter. I cited that in my brief. And Attorney Scanlon, who I don't know, but I understand, am I done?
20 seconds.
Okay. He wrote him a letter. They knew there was something wrong there. If they didn't want their honor to be hurt, they could have tried to deal with him, with whatever lawyers they had at the time, and see if they could resolve this before it went to litigation. If I have 10 seconds here. Okay. It wasn't that important. I would have said it before. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision, which will be available to both sides as well as posted to our website and the Supreme Court. The court will take a short recess to